Well, hello, Uncivil Law fans. I hope you're having a great day. And for today's story, we are turning our attention to the U.S. Supreme Court. It is going to be a great and glorious day of major decisions at the U.S. Supreme Court, and we are looking forward to them. It's that time of the year. It's the end of June. For those of you unfamiliar with it, the Supreme Court's oral arguments go from the first Monday in October to the last day of June, and they historically release all their decisions by the end of June. They have once gone into July, but it's not really their practice. And in any event, they only have something like 12 cases left to decide. So we're expecting roughly half of those today, and then presumably the other half next week. And they can't all be the major cases reserved for the last day, right? There's quite a good few good things left in the case. Birthright citizenship, trans athletes, and a whole bunch of other issues, mail-in ballots. So I'd expect mail-in ballots today. I'd expect the trans athletes case today. Probably not the birthright citizenship case today. I would expect they probably reserve that for the last day so they can drop their mic and peace out. But, the Supreme Court does what the Supreme Court does, and you don't know what they're going to release until they do. What decisions will they release today on civil? I don't know, and neither does anyone else. You don't know until they open the boxes at the Supreme Court. So we will follow this as it goes every step of the way. And good morning. I am hyped. So let's see what SCOTUS blog is saying so far this morning. Not much. Let's see what they're saying today. Okay, so yeah, there are 12 decisions today. Could they release all 12 decisions today? No. That is not a thing. There's no way. Half of those is much more plausible. Yeah. Someone says they think we'll only get birthright today. That seems unlikely to my mind. If we do get birthright today, I don't think it will be the only thing today. They would want to bury it in other things. And I would suspect, all things being equal, they'd want to bury it in higher profile decisions, right? Because you don't want to be the only high profile decision. So if you're going to do birthright citizenship, you probably want to release it with other major decisions so that there's more noise or more signal, actually. And it's hard to cover everything, but we'll see. There's also Wolford versus Lopez, which has some Second Amendment implications, dealing with Hawaii's rule on concealed carry. That will presumably go against Hawaii, which is good for the Second Amendment people. No immediate practical consequences, because Hawaii has sort of changed its mind since then. So the decision won't have immediate practical consequences, but it will tell Hawaii they did it bad and prevent states from doing bads in the future. So that's a very likely decision. Wolford versus Lopez today, overruling Hawaii on their rules relating to concealed carry because it was basically impossible to get a lawful carry in Hawaii. And they will decide against Hawaii, but it won't have immediate practical impact, but it will develop the Second Amendment law, which is fine because it will prevent other states from doing bullshit in the future, at least the same bullshit. So I'll take it. That's probably going to happen today if I were a betting man. It does have some complex interactions of Second Amendment law with property law. And so there is some things, but probably not as much on practical consequence. There's also the case of Mullin versus Otro Lado, whether aliens who stopped on the Mexican side of the border arrive at the United States within the meaning of various law, because it deals with asylum claims. So if you arrive at the border, right, if you arrive at a border control point, is that arriving in the United States? Right? Is that arriving in the United States for the purposes of asylum claims? I think the better answer is probably yes, that it is, because it's much cleaner that way, to my mind, that the answer is yes, because it allows for that lawful channel so that you arrive at a border control point and can make your asylum claim. And that's deemed to be in the United States, even though it's kind of no man's land. Doesn't really belong to anybody, but let's say it is for the purposes of the statute. I think that's probably the correct, that's probably the lawful interpretation. Because you got to give people a means to apply for asylum. And if they have to do it in the United States, they have to already be here. That's odd, right? So it's like you probably want to do it so they can do it at a border control point and have that option. So that seems plausible to me. So I think that's probably the better interpretation, but that's a decision we'll probably get today. Yeah, so does a border control point count as being in the United States? Yeah. Yeah. That's fun. And for a lot of purposes, the answer to that question is no, right? Even if you fly here, right? So if you fly here and you fly into, I don't know, JFK, for example, but you haven't reached border control yet, you're not necessarily in the United States for all purposes, or even most purposes, to be honest, because like obviously they can deny your entry, right? Because you haven't reached border control yet. So the Customs and Border Patrol people can be like, no, not so much for you. We're not quite sure how you got on the plane in the first place, right? We're not quite sure how that happened, but that's no longer our problem. Just turn around and get out, right? Because you're not in the United States yet. You haven't reached border control, even though you're standing on JFK. You're standing in New York, but you're not in the United States yet, right? For all purposes, or a lot of purposes. But you're in the United States, or are you? Right? So you wind up with those kinds of weird things. So it's probably just easier to say yes, for the purposes at least of claiming asylum, putting aside what might be true for other issues, right? Putting aside what might be true for other things. For the purposes of claiming asylum, are you in the United States? Sure. Even if you're at the land border and you're on the other side of the Mexican border, are you in the United States? Sure, why not? It's probably cleaner that way. So that seems like a very practical answer. So Congress, this is going to be one of those things where we fudge a little bit and say, well, when Congress wrote in, what they really meant was ... right? So yeah, that kind of thing. Yeah. Abolish the asylum system. You can do that too. Although to do that, obviously you have to amend the statutes. So if you want to get rid of it, yeah, like I'm not here to tell you what laws we should have with respect to immigration. That's not my role, right? I'm not. If you think that we should have totally open borders and we should have no border control points, that's a policy issue. If you think our borders should be completely closed and we should never let in anyone ever, that's a policy issue. If you think we should have asylum claims or not, that's a policy issue. I don't do policy, I do law. So like, yeah, I'm not here to tell you whether or not we should have asylum claims or have immigration law or anything like that. I'm just here to tell you what the law we have means and help interpret Supreme Court to that end. Yeah. And then if you don't like it, contact your Congress critter. And if you're like, well, Congress is broken, I'm like, I don't know what you want from me. I'm the judicial branch. Congress is broken. Oh, well. I don't know, tell you. Not my problem. So, no. Yeah. Got to stay in my lane. You know what I mean? Yeah, exactly. Well, you voted for them. Yeah, pretty much. That's the Supreme Court. And that should be the Supreme Court's attitude, right? We're here to interpret the law Congress passed. We're not here to change the law. We're here to interpret the law. And although we think Congress is a smart Congress and writes exactly what they mean, don't you know? Sometimes we have to fix what I'm sure were completely inadvertent and unforeseeable errors. But we got to keep in our lane. Yeah, the citizenship issue is not going to go in favor of the conservatives. Let me just spoil it for you. That's not happening. The birthright citizenship case is going to be decided against the wishes of the Trump administration. Let me just spoil that for you. There is no way on this earth they are going to decide the birthright citizenship case in favor of the Trump administration. It ain't happening. You don't have the votes. You don't have anything close to the votes. So, not happening. No. Anyone born here other than the child of an ambassador or a person actually engaged in an act of war in the sense of being a troop or a Native American, they don't count. But anyone other than those people who are born here is a U.S. citizen. That's what the decision's going to be. Who will write the decision? That's a good question. Who writes it? Probably Kagan. I don't really imagine any of the Republicans. Maybe Roberts. Maybe Roberts if he wants a piece of the hate. Why am I wearing earphones anyway? Like I'm going to be listening to audio. There's no audio. We don't do audio. There's no audio. There's just text. Why am I wearing earphones? Like I'm going to be listening to audio. What am I doing over here? Yeah, it's kind of funny when I list off the exceptions. Yeah. Who doesn't count as a native-born American? Who doesn't count as a natural-born American? Native Americans don't. I know. It's endlessly hilarious. Who does not? I mean, that's the Supreme Court. Who does not count as a natural-born American? A Native American doesn't. Don't look at me. I'm just the messenger. I'm not saying this. The Supreme Court is saying this. Don't look at me like I'm saying things. I'm just telling you what they said. I'm just the messenger. Don't shoot the messenger. I'm here to explain Supreme Court. Not necessarily agree with it, as I want to do from time to time, as I do disagree with them, such as for Wickard v. Filburn, which will endlessly burn in effigy until the end of time. Jackson, you don't want Jackson writing that decision. Kagan, although left-leaning, is a serious intellectual. I respect Kagan. I don't agree with Kagan, but I respect her. She is a thoughtful, well-educated, well-reasoned, left-leaning person. Now, I think she's wrong on a lot of her priors. So she gets things wrong because she has the wrong priors. But she is a thoughtful, left-leaning judge. Less could be said for example, Jackson, by comparison. So Kagan writing the decision makes sense because Kagan is an intellectual. Just let that hang in the air there by implication. Also, apparently, it's Justice Sotomayor's birthday today. So happy birthday, Justice Sotomayor. Okay, moving on. Doesn't Gorsuch have history with the Native Americans? He sure does. He sure does, yes. He wrote the decision in the Oklahoma case where he decided that half of Oklahoma wasn't in Oklahoma. Yeah, so Gorsuch has some Native American cred because he's for the Supreme Court, he's what counts as an expert. That isn't to discount Gorsuch. It's just to say that like no one is particularly an expert in Native American law because, but for the Supreme Court, he's the expert. And he wrote the decision that said half of Oklahoma isn't in Oklahoma. So yeah, Gorsuch is definitely your Native American specialist. Good times. Gross. He was right. He was absolutely right. He was correct. If you go read the decision, he was absolutely 100% correct. I mean, it is what it is. Congress, in its infinite wisdom, wrote some laws relating to Native Americans. And, the laws are what they are, even if they're more than 100 years old. They're really old, bro. The conservatives don't care. We're all about that really old law, right? Oh, they wrote this like more than 100 years ago. Oh, okay. That's nice. And Gorsuch was right. He's 100% right. Big balls decision, but he was right. It was constitutionally based. If you have a problem with this, incidentally, by the way, go talk to Congress. Congress can fix this, right? Because it's all about what Congress wrote. Congress has the power to just change it magically. All they have to do is pass a statute. Good luck. Yeah. Good times. All right. We have our first decision. Let's see what we got. Let's make it look all pretty. Yeah, Gorsuch is all over here. Like, I just work here. He has, I just work here energy, and he's not wrong, man. So I respect him. All right, Monsanto. Okay, I'm sure this will be good and in no way controversial in any way. Let's read this thing. We turn our attention to the case of Monsanto, the crop people versus Dornell. This should be good. Monsanto Company manufactures and distributes Roundup, a herbicide designed to control weeds. The EPA has repeatedly evaluated the substance that they use and repeatedly concluded that the substance is not likely to cause cancer. Okay. The EPA assessment is shared by many other regulatory bodies around the world. Roundup does not cause cancer, says a lot of the world's health authorities. Okay. In accordance with the EPA's view that this substance is not likely to cause cancer, the EPA has not required labels on that to include a cancer warning. We don't think it causes cancer, so we're not going to require labels saying it might cause cancer. Okay. In 2019, Dornell sued Monsanto in state court, alleging that he had used the Roundup products for around 20 years and that they had caused non-Hodgkin's lymphoma. He thinks it might have caused a little like cancer. As relevant here, Dornell brought a failure to warn tort claim, asserting that Monsanto should have included the cancer warning on the Roundup label. A jury agreed and awarded him more than $1 million in the failure to warn theory. Not a chance. Not happening. No, that's going away. On appeal, the Missouri Court of Appeals affirmed the Court of Appeals rejected Monsanto's argument that the Federal Insecticide, Fungicide, and Rodenticide Act expressly preempted the failure to warn. The court grants cert. Held, it preempts. Of course it does. Of course it does. Yes, the relevant federal law preempts the state failure to warn claim. This is not super complicated. This is just interstate commerce. Okay, Roundup is a substance that's sold across state lines. I don't know if you've noticed. And sold across national lines. I'm not sure if you've noticed. Who gets to regulate interstate commerce? The feds do. Okay, the feds passed a law that says, hey, we're going to regulate these substances. Right? We're going to regulate these substances and we're going to determine whether they're super duper bad for you and stuff. And the feds say, in our infinite wisdom, they're not super duper bad for you. And Missouri's all over here like, we think they might be bad for you. Or at least a jury in Missouri thinks they might be bad for you. And the Supreme Court's like, federal supremacy. I mean, you know, that makes sense. The federal law preempts because the claim would require Monsanto to add the warning to the label. The relevant law, the preemption clause, which is entitled uniformity, provides explicitly a state shall not, a state shall not impose or continue in effect any requirement for labeling or packaging in addition to or different from those required. Do we have to keep reading? I mean, do we really have to keep talking at this point, right? A state shall not impose any requirement in addition to or different from labeling. Missouri's like, you know what we'd really like to do? We'd really like to have something in addition on the labeling. Wow, that sounds like a conflict, people. You know, I'm no expert or anything except for the fact I totally am. That sounds a bit like a conflict. Geez, I wonder who's going to win that fight. The federal government who gets to regulate interstate commerce or the state? Which way will it go? It's so hard to tell. The relevant law, therefore, preempts the state law requirement that differs from federal law requirement imposed under the law. Blah, 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 blah. No muss, no fuss. And this decision is, what was it? It is 8-1 with, apologize, 7-2 with Jackson and Gorsuch dissenting. Exciting and fun. Great. Moving on. Next case. What? They've taken down links. The Supreme Court has broken its page and there are no links. Thank you, Supreme Court. All right, let's try this. Let's see how this goes. We turn our attention to the gun case. Wolford versus Hawaii. For years, the state of Hawaii has made it almost impossible to obtain a license to carry a firearm. Yep. 4 years ago, however, this court held in Bruin that the Second Amendment actually means stuff, including the right to carry a handgun outside the home, at least sometimes in some circumstances. Yeah. Hawaii responded to this by replacing its old law on carry laws with new laws that achieved a similar result. So the old law was like, no. And the new law was like, yes, but no. So they changed it, but not really. At issue in this case is the Hawaii law that prohibits firearms on private property open to the public without express and affirmative consent. Okay, so here's what Hawaii did to solve their problem, right? Hawaii does not like guns. Massive shocker, I know. That left-leaning state, Hawaii, they're just pro-Second Amendment through and through, don't you know? Oh, wait, no, not so much? Oh, what a surprise, right? So here's what Hawaii did. It's like, okay, we have to issue concealed carry permits. But what we're going to make it do is opt in rather than opt out. So in every state, except Hawaii pretty much, you can put up a sign that says no guns allowed, right? As a private business, because you're a private business and you can decide who has guns or not. And What Hawaii said was, what if we did it the other way around? What if the default was no, and the business had to explicitly put up a sign or otherwise grant permission for yes? So you have a concealed carry permit, but you can't take it anywhere, at least in any private business, unless the business explicitly gives you permission, presumably by posting a sign or otherwise. So what if we flipped it? What if we flipped the presumption so it was default no? And then businesses had to explicitly opt in. How's that going to work? Right? All right. Hawaii's new rule imposes severe restrictions on the daily activities of residents and non-residents alike who get the permit, who have satisfied the state's rigorous requirements for the issuance of that permit. When those permit holders leave their house, not only must they take care to avoid all the territory where possession of guns is prohibited outright, because of course there's a lot of places where it's banned by law anyway. So there's a lot of places where just no. But they might also be barred from entering many places that people routinely visit in the course of their daily routines, such as gas stations, restaurants, and stores. The law flipped the default rule at common law, under which anyone has an implied license to enter property held open to the public unless explicitly withdrawn. In District of Columbia versus Heller, this court held the Second Amendment protects an individual right to keep and bear arms, with the amendment's central concern being the fundamental right of self-defense. Heller instructed courts to ascertain the scope of the right by looking to history and tradition tests. Again, and emphatically rejected a ahistorical, judge-empowering, interest-balancing inquiry because that sounds like some bullshit. The court later held in McDonald that the Second Amendment right applies equally to the federal government and the states through the 14th Amendment, settling the question of whether the Second Amendment embodies a uniform national standard or one that varies from one location to another. Yeah, the Second Amendment, like all the other amendments to the Constitution, means one thing. Right? The First Amendment means the same thing everywhere in the nation. And the Fourth Amendment means the same thing everywhere in the nation. The Fifth Amendment and all the other amendments mean the same thing. And maybe the Second Amendment too? Yeah? The Second Amendment means the same thing everywhere? Oh, okay, cool. That makes sense. What a shocker, right? These are deep revelations. In Bruin, the court fleshed out the process of historical analysis requiring in a Second Amendment case, holding that the analysis involves two steps. First, the court must determine whether the challenged law falls within the plain text of the amendment's language by asking whether the law applies to the people, that is, all the members of the political community, and restricts the keeping, that is, possession or bearing, of arms. If a challenged law falls within the plain text, it is presumptively unconstitutional, which means that it may violate the pre-existing right the amendment codified. But the government may show the challenged law did not infringe the historical understanding of the codified right. Yeah, I wouldn't quite frame it that way. I think that's slightly the wrong way of framing it, although you get to the same place. For me, it's more about the boundaries of the right than an exception to the right, right? It's like, what exactly is the right to keep and bear arms? What exactly is it, right? That is a thing that has borders. We've discussed this before, right? Is a thing that has borders. So to my mind, it's better not to think of exceptions to the First Amendment, but rather things that are just, or Second Amendment for that matter, but just things that are categorically not within it. For example, in the First Amendment context, defamation, right? Is defamation an exception to the First Amendment? If you ask me, I'd say no, it's not an exception to the First Amendment because it's just not included within the boundaries. It's speech, but it's not part of the freedom of speech, right? Just because it's spoken does not mean it's within the freedom of speech. The freedom of speech is a concept that has borders that are not coextensive with speech. They're slightly different concepts. So defamation is not an exception, it's just categorically excluded. Same thing in the Second Amendment arena, to my mind, but maybe it's a distinction without a difference. It's a very technical point, but that's how I think about it. In any event, but the government may show its challenge law did not infringe the historical understanding of the codified right, which kind of gets you to the same place in the end, so maybe it doesn't matter. While a variety of sources may aid this inquiry, the best evidence is often what Bruin called historical analogs. old legal rules from which a court may draw strong inference that a modern law is consistent with codified right. In other words, can you find something that's really, really close in history? Which you would do in the First Amendment analysis too. Nothing up your sleeve. Brune identified 3 important inquiries for evaluating proffered historical analogs: the number of jurisdictions in which they were adopted, to the extent they were well accepted, and whether any analog or collection of analogs is relevantly similar to the modern terms of how and why. In other words, in history or tradition, we're not looking for one-offs. We're not looking for like some random court somewhere that said some bullshit. We're trying to determine what the commonly understood understanding was. So you're not looking for, some crazy judge who said some bullshit. What you're looking for is the collective common understanding. It's common law. You're looking for the common understanding. And the more jurisdictions and the more well accepted, the more common it is. The more common it is, the more it's common law. Right? I mean, makes sense, right? Petitioners, 3 residents of Maui County, who possessed concealed carry permits and an organization, filed suit in federal court seeking injunctive relief, contending the laws violates their rights. Held, Hawaii's law prohibiting licensed concealed carry permit holders from carrying handguns on a private property open to public without express authorization violates the Constitution. Excellent. That takes care of that. What a fun decision by all. Okay, we have another decision. Let's read. We will do this in more depth, but right now we're doing speed read. All right, Mullin versus Otro Lado. The Immigration and Nationality Act governs the process by which aliens who arrive in the United States and inspected by border officials are deemed to be an applicant for admission and may seek asylum. This is what counts as being in the United States. That's this decision. Great. The question in this case is whether an alien who seeks to enter the United States from Mexico arrives in the United States within the meaning of the phrase in 2 key provisions: when the alien is standing in Mexico at the border, or only when the alien crosses the border. So yes, if you're on the Mexican side of the border, but you're at the border checkpoint, are you in the United States? For the purposes of this law, I think the answer is yes, for a bunch of practical concerns. So I'm going to say the Supreme Court says yes because no just is weird, and yes seems like the easier solution. So yes, even if you're standing in Mexico, but if you're at the border checkpoint, you're in the United States enough for the purposes of this law. That's what I think the answer is. Let's see. In the spring of 2016, U.S. Border Patrol began experiencing a surge of aliens seeking admission at ports of entry along the U.S. border, with numbers sometimes exceeding the safe and secure processing capacity. In 2016, the Department of Homeland Security responded by adopting a policy of metering the number of arriving aliens who Border Patrol would inspect each day and allow to apply for asylum. To enforce the policy, officials stood on the U.S. side of the border and prevent aliens from entering the United States beyond the number the port could adequately process. I mean, there are practical limitations. We're doing our best. The metering policy continued through the change of the presidential administration. In 2017, asylum seekers and the immigration advocacy organization Otro Lado brought a putative class action against the government in the United States District Court for the Southern District of California, arguing that Border Patrol's enforcement of the metering policy unlawfully withheld inspection and asylum processing from aliens who arrive at the border and seek to enter the United States. The District Court certified the class of all the people. The court grants summary judgment for the class and declared the government's denial of inspection and asylum to class members who were in the process of arriving in the United States as unlawful, regardless of the preferred justification for doing so. I think they're going to disagree with that. Right? There are practical limitations. So I think the Supreme Court's going to split the difference. Yes, at the border counts for being in the United States. But even though that's true, there are practical limitations. And as long as they're doing their best, then it's okay. So I think they're going to split the baby. The government rescinded the metering policy in 2021, shortly after District Court entered summary judgment. A divided panel of the Ninth Circuit then affirmed, holding that aliens arrive in the United States and must be inspected and apply for asylum when the alien standing on the Mexican side of the border encounters. Okay. Well, Apparently, the Supreme Court's going to go the other way on this one, so my prediction is wrong. An alien standing in Mexico does not arrive in the United States by attempting and failing to set foot in this country. An alien arrives in the United States only when he crosses the border. The INA thus neither entitles an alien standing in Mexico to apply for asylum nor requires an immigration officer to inspect him. I am genuinely surprised. I thought they would go yes for a bunch of practical reasons and maybe split the difference, but they are going with no. So, okay. The case is not moot, sure. The phrase arrives in the United States is to carry its ordinary meaning. Okay, fair enough. Respondents' principal textual arguments rest on a canon against surplus. They observe that a different law allows asylum applicants by people who arrive in the United States and also by those physically present in the United States, and they argue the first phrase would be redundant if required to be read in the second. It has some force, but does not overcome arguments pointing the opposite way. So there is some surplus here, but that's okay. We can do surplus. Okay, fair enough. Even if the texts were not enough, the presumptive against extraterritoriality, that's a hard word to say, would tip the scales against respondents. That's a fair point. U.S. law is presumptively not valid outside the United States unless Congress explicitly says so. So Congress is thought to only act within its borders unless it says clearly otherwise. The remaining arguments fail, blah, 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 blah. Alito delivers an opinion of the court in a Sotomayor, Keegan, and Jackson 6-3 opinion. I am slightly surprised, but hey, I'm not God, so fair enough. And they are still reading from the bench. So we are now caught up because they announced their decisions from the bench and someone is still talking. So presumably someone's reading their dissent from the bench and taking their sweet time. So we can pause for a second while we wait for the Supreme Court to catch up with us. Lol. I am a bit surprised. I mean, they're not wrong. It does say in the United States, so that's a very strict textualist. I'm not surprised Gorsuch reads it that way because he's very strict textualist. I thought they'd go the other way for pragmatic reasons, maybe split the baby, but nope, they're going to just read it the way it's written. I mean, I can't be mad at it. It is textualist. I just thought that, they on balance go the other way. But I was wrong. Oh well, what can you do? We'll read it more in depth. Don't worry, we're not going anywhere. We're just doing speed read for the moment. Okay, it looks like we have our final decision today. So we still have 8 decisions left to go. That's exciting. All right. We turn our attention to the final decision from the U.S. Supreme Court for today. The case of Mullin, the Secretary of Homeland Security versus Doe. Homeland Security versus Doe. The question is whether respondents who challenge the termination of a temporary protected status for aliens from Syria and Haiti are entitled to orders postponing their terminations during litigations. Congress created the relevant status in 1990 to protect short-term humanitarian relief for aliens who cannot safely return to their home countries. Although designed to afford temporary relief, and you know right away where this is going just by the way it's written, the TPS, really, we're doing TPS reports? Seriously? We're doing Office Space now? We're doing TPS reports? We're doing TPS reports. Okay, fine. Although designated to afford temporary relief, the TPS designation in practice has often lasted for decades. Well, that doesn't sound very temporary. Syria received the TPS designation in 2012 because of extraordinary and temporary conditions related to the repressive regimes of Bashir al-Assad. And in September of 2025, which is 13 years later, the Secretary of Homeland Security provided public notice that the TPS designation for Syria would terminate. 7 Syrian nationals sued, asserting claims under the Administrative Procedures act to stop the termination, which is always your go-to law when you want to sue the feds, right? You want to sue the feds for doing something, the APA is usually a really good place to start. The APA is the law that says how you do regulations, right? It's the law that says how administrative agencies have to come to decisions. So you want to sue an administrative agency because they made a decision you didn't like, the APA is probably going to be where you're going to start. No surprise there. The district court concluded that the plaintiffs were entitled to interim relief. The Second Circuit denied. Haiti received the TPS designation in 2010 after a devastating earthquake. The secretary provided public notice that the Haiti TPS designation would terminate. 5 Hawaiian nationals sued in district court. Well, this is technically 2 cases, right? So this is technically 5 cases decided with 7 cases left. 5 Hawaiian nationals sued in district court for the District of Columbia, asserting claims under the APA. The determination of TPS designation violated the Constitution right for equal protection. The district court granted interim relief, and the divided DC panel declined to stay. The government sought to stay in writ of certiorari. The court's grants review. Held. The TPS statute bars judicial review. Yeah. We have no power. The relevant law provides there is no judicial review of any determination with respect to the designation or termination of the designation. Well, that sounds kind of, sounds pretty clear, right? It's for the executive to decide. It's the executive decisions alone. There's no review of their designation. Their will is absolute in this respect, or quasi-absolute. You gotta look for those like exceptions. But when it says no judicial review, yeah. The term determination may mean either an individual decision or the process leading to the decision. Under either understanding, the relevant law bars all the non-constitutional claims. Further, the phrase with respect to generally has a broadening effect, ensuring the scope of the provision covers not only the subject but matters relating to it. So yes, you can't challenge it under normal APA rules. The APA, because the APA is generally speaking, right, the rule for how to make a decision. If you're an administrative agency, such as, for example, Homeland Security. We can all agree Homeland Security is an administrative agency, right? They're an agency inside, the executive branch, otherwise known as the administration, right? We're all clear on this much, right? Homeland Security is an executive, otherwise known as administrative agency, right? Great. All right. So the Administrative Procedures Act, right, is the procedures for the acts of the administration, such as, for example, Homeland Security. Cool. It is the rule book for how to create rules. That's what it is. It's the rule book for how to create rules or how to make decisions, which is a rule. Okay? Generally. But of course, in law, it's never that simple. Because you guys know that it's not that simple, right? There's asterisks everywhere. You know that. You should know that. There's asterisks everywhere. So the Administrative Procedures Act is the procedure by which the administration takes action, except ... Except when, might you ask? I'm so glad you asked. When there's another statute that says, yeah, not so much. Because what Congress giveth, Congress can taketh away. And as a good rule of interpretation, the more specific overcomes the more general. So if you have 2 statutes, right, and it says, generally speaking, government, when you want to do stuff, here's how you go about doing stuff, okay? And then you have another statute that says, hey, Homeland Security, in this specific domain, how would you like to be God? What you know right away, right? Just from the the fact of these two realities. What is going to rule? Which one is going to rule? Is the one that's going to rule being, hey, generally speaking, administrative agencies, such as and including Homeland Security, generally speaking, here's how you want to make decisions, generally. More specifically, how would you like to be God? Which one is going to control? The more specific is going to control. It's, in the end, it's that simple. Congress creates the law, and they can create exceptions to the law, and God knows they do. Right? There are exceptions built on exceptions built on exceptions. And you know there's an asterisk, by the way, to the you get to be God thing, because of course there is. Somewhere there's an asterisk, and there's probably an asterisk to that asterisk because, you know, it's turtles all the way down, because that's how we do law over here. But, you know, when the secretary says, you know, this is my designation, that's the end of the discussion. And you can't sue under the APA. So your only thing left is the Constitution. Because you know what beats statute, right? You've got two statutes. You've got statute that says, hey, administrative agency, here's generally how you do stuff. And statute that says, hey, Homeland Security, how would you like to be God? You know what you can do? You go to their boss, right? What is their boss? The Constitution, right? The Constitution is the supreme law of the land, don't you know? So you can still find a constitutional claim, which, by the way, for the purposes of this, is going to be arbitrary and capricious. Basically, if the secretary, or Homeland Security more properly, because they're all doing things in the secretary's name, but either way, could literally be the secretary himself, although not usually. But either way, as long as they're not just throwing darts at the board, as long as they're not, you know, just looking at chicken entrails, as long as they're not, you know, drawing balls out of a bingo hopper, as long as there's any reason, rationality, system of any description, as long as it's not bullshit we just made up because, it's going to withstand scrutiny. Arbitrary and capricious is your only guardrail left, and good fucking luck with that. Great. So, now that we understand the Constitution completely, let us go and look at these decisions with a little bit more care. So we're going to read the syllabus, which is the summary of the case, thoughtfully put together by the court, that explains the thing. And we'll explain it in a little bit more detail. All right. Let me just fix the margins a little bit so they look even prettier. How do I make it look even prettier? Hey. Yeah. Let's make it look nice. Yeah. There we go. Ooh, that looks nice. All right. Let us start explaining it in more detail with Wolford versus Lopez. Now, first of all, I have to say that I'm very pleased. What is this, like the second Supreme? This is like the second Amendment decision this year? Or is it like even the third? I don't know what to do with this information. It's like Christmas time. The Supreme Court has decided to actually hear Second Amendment cases. What? Right? I mean, I'm not against it. It's just like, we decided to actually hear Second Amendment cases now. That's nice. Who knew, right? All right, great. So let's go back to Wolford and read it in more details. So we read the initial summary. So let's read the holding. Hawaii's law prohibiting licensed concealed carry permit holders from carrying handguns on private property open to the public without the property owner's express authorization violates the Second and 14th Amendment. The restrictions imposed by Hawaii's challenged law fall within the plain text of the Second Amendment, so the law is presumptively unconstitutional. Sure. No party disputes that petitioners are among the people. That would be hard. protected by the Second Amendment, or that they seek to bear arms. That would also be a little bit hard in this context. Therefore, the plain text of the Second Amendment protects what petitioners want to do, namely carry handguns for self-defense and other lawful purposes. To be sure, owners of establishments that are open to the public can admit or exclude persons who are carrying guns for self-defense under either common law or Hawaii's law. I mean, it is private property, and you have the right, in the absence of law to the contrary, when it's your private property, you have the right to allow or not allow people onto your property on your whim. Right? Now, there are a lot of laws that govern that, particularly in commercial spaces, because it's a little bit hard to be like, yeah, I'm open to the public, and also I want to be God over everything that happens in my space at the same time. It's a little, yeah. So that has never really been the thing for a long time. Even in common law, that's not really been the thing. It's like, you can't necessarily have everything all at the same time. If you want to be open to the public, that with the good comes the bad, with the bitter comes the sweet. So if you want to be open to the public in a commercial sense, that comes with benefits. You get to sell stuff, and it comes with some potential detriments, namely liability to you for a whole bunch of things. And that's been common law for a long time. And of course, the statutes on top of that. So, nothing up our sleeves there. But generally speaking, you have the right to decide who you want to do business with, generally. But the government deciding on your behalf is a whole other set of problems, right? Because that gets into what the government's role is versus the private property person's role is, and so forth. The restrictions imposed by Hawaii's challenge law fall within the plain text of the Second Amendment. Therefore, the plain text protects what the petitioners want to do. To be sure, the owners of the establishment that are open to the public can admit or exclude persons who are carrying guns for self-defense or any other lawful reason. But Hawaii's shift from the common law rule, where it's, presumptively allowed unless the owner themselves interacts. Because remember, when the private party does stuff, the private party is not the government. So in the absence of a law to the contrary, if I own a business and I discriminate against you, in the absence of a law to the contrary, I can do whatever the hell I want because I'm not subject to the Constitution, because I'm not the government. The Constitution restricts the government, not me, the business owner. A statute might restrict me, but the Constitution doesn't. Right? So I get to do whatever the hell I want in the absence of a law to the contrary. For example, proprietors who do not object to entry by carry permit may be reluctant to post signs, welcoming signs, for fear of alienating customers or retaliation or a whole bunch of things. So under Hawaii's new default rule, a proprietor in this category may only be willing to consent discreetly to the entry of permit holders who make an effort to inquire. This arrangement imposes a burden on permit holders who will have to somehow obtain permission to carry firearms on property, and at that point, every single individual piece of property. So even if you could negotiate this for one convenience store, good luck on negotiating it for all the convenience stores and grocery stores and, fast food restaurants and blah, blah, yeah, good luck on that. The arrangement imposes a new burden on permit holders who have to somehow obtain permission before stepping foot on that property, and to the point, all property. The law severely hampers the ability of law-abiding citizens to exercise the right under Bruin. Hawaii's proffered historical analogs do not support the constitutionality. So the government wants to do a restriction. Hawaii is the government, pretty sure about that. And Hawaii would like to impose a restriction, right? They'd like to say that you can't do something or you must do something. Okay, well, states' rights and all, but Constitution beats that. And the Second Amendment has been incorporated under the 14th Amendment. So they're subject to that. So can the government do this bullshit? Hawaii's argument is that its particular customs and laws support a new default rule fails because the Second Amendment has had the same meaning in all parts of the United States. True. The Second Amendment cannot give the way to the spirit of a law. They actually made that argument. That's hilarious. I can't believe the Supreme Court actually said that out loud, because they actually said that. I forget at what point they said that in their arguments, But like, did they say that in court or did the governor just say that? But at one point, the Hawaii government actually said that. They said, you know why our restrictions on the Second Amendment are okay? You know why they're okay for us, Hawaii? We can't speak to Delaware. But you know why they're okay for us, Hawaii? Because the spirit of aloha. They actually said that bullshit. And the Supreme Court's quoting it back at them. And I find that hilarious. Merely local attitudes can neither shrink nor inflate the meaning of the guarantee of the Second Amendment. Yeah, that'd be really weird. Because if the spirit of aloha were a thing, then the spirit of every other state locality would be a thing. And well, that doesn't sound like a uniform rule to me. That sounds like a fucking nightmare. There are 3,000 counties in the United States, so that sounds like a lot of fun. The state's colonial and early state law analogs consist almost entirely of laws that prohibit unauthorized hunting of deer or small game on someone else's private property. These laws, including Pennsylvania, New Jersey, Maryland, New York, and New Jersey, targeted unauthorized hunting and applied to land where game could be found, not retail establishments. Lord, that's good shit. Those laws have little, if any, impact on the Second Amendment's central objective of protecting the fundamental right to self-defense, and their obvious aims was to prevent the distinctive harms and risks associated with unauthorized hunting. The gap between the state's anti-poaching and its new Rules 2 law. I mean, to be fair, when we're interpreting the Second Amendment, like we interpret any other amendment, we absolutely need to look to the common law. That is absolutely a thing, as I've said, and I will say before again, as I've said before, and I will say again, the right to keep and bear arms is a concept that has borders and must be properly understood. And just because it is an arm, right? Just because it's an arm does not mean it's protected by the right to keep and bear arms. That's me saying that. And I think correctly. In the exact same way, mind you, that just because it is spoken does not mean it's protected by the freedom of speech. Right? Defamation, for example, true threats, by example, right, are not part of the freedom of speech. They're not within the border of the thing. It might be spoken, but it is not part of the freedom of speech. The freedom of speech and speech are not the same. So in the exact same way, the right to keep and bear arms and arms are not the same thing. So just because it's an arm does not mean it's protected by the Second Amendment. But that's a whole other discussion. Anti-poaching laws, to the point, however, have been part of the common law since forever. The king, when there was a king, and of course, being common law, we have to take that part of history too. So the king, when he was saying, no poaching, that's part of the Second Amendment tradition too. So anti-poaching laws are not in infringement on the Second Amendment. Sorry. Because they were always excluded because the king said so several hundred years ago, and that's still a thing. So, moving on. All right. Anyways, carrying on. So anti-poaching laws are okay with the Second Amendment, but, you're not doing a lot of poaching at 7-Eleven, so it's kind of neither here nor there. The state's remaining analogs are even weaker. An 1893 Oregon law prohibited armed trespass on enclosed premises, but it's unclear whether such premises include commercial establishments open to the public. Regardless, a lone statute adopted nearly a century after the adoption of the Second Amendment, and well after the adoption of the 14th Amendment, shed little, if any, light. Yeah, it's too late. 1893? Yeah, that's a little late. The Second Amendment means what it means in 1791. So a lone law in 1893, not much help on that domain, so we get to ignore that, and no problem with that. Let's move on. Yeah. Yeah, check your 6 says, I think you're wrong. All arms are protected. The use of said arms are not protected. Yeah, I disagree. It doesn't, it's a very pedantic point because in the end we kind of get to the same place, but it's just the way I think about it. It's more about the borders of the thing. I think that, yeah, it's in the exact same sense as the First Amendment, right? So for me to say defamation is not protected, right? If I speak it, if it's slander, slander is spoken. So it's spoken word. Is it protected by the First Amendment? No. Okay, so there's two ways of looking at that, I suppose. You can think of it as an exception to the First Amendment. That's one way of looking at it. But I think it's better not to think of it as an exception, but just categorically exclude it. It's not an exception, it's just not within the category at all. So slander, although spoken, it's undeniably spoken, is not within the freedom of speech. So it is not speech for the purposes of the freedom of speech. That's how I think about it. I think about it in that categorical way. I think it's a better way of looking at it. It's just appeals to my sensibilities. So in the exact same way, therefore, if slander is categorically not part of freedom of speech, if it is speech, but not protected by the freedom of speech and speech are not coextensive. Therefore, the right to keep and bear arms and arms is not coextensive. Therefore, slander being categorically excluded means that there are some kinds of arms that are not arms for the purposes of the Second Amendment protection. What are those arms? There's a whole nother set of discussions, but that's neither here nor there because at the moment we're not making that decision. It's just a very technical point about how I think about it. Yeah. Yeah, and then check your 6 says, yeah, or Konsaki says, what the legal definition of arms? Yeah, this is a problematic question because when you say, what is the legal definition of arms within what context, right? Do you mean specifically within, it doesn't mean the same thing in every context. That's the problem, right? If you ask me, what's the definition of arms? Within the meaning of what, right? Because it means something different, at least in my mind, within the meaning of the Second Amendment versus an arms control treaty versus whatever, blah, 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 blah. So it's like, yeah, if you ask me specifically what it means within the context of the Second Amendment, to answer that question, we have to go through history and tradition to decide what kind of arms are protected. And that's not important right now. So let's just focus on this for the moment, but it's very, yeah. Slander is protected in that you're allowed to say it without criminal charges? Not necessarily. Yeah, you're just wrong on that one. Can the state criminalize slander? Yes. Louisiana does, at least in some respects. So can you have a criminal law against slander and defamation? Yes, you can. A lot of states don't, but they can. So if a state passed a criminal law against slander, can they do it? Yep. That they don't is neither here nor there, but Louisiana does, and you can do it. Yeah, you can do it. We normally think of it as a civil infraction, but can it be criminal? You bet your ass. Absolutely can. And to the point, for example, true threats are criminal, and no one has a problem with that. So if you want to example that's routinely criminal, true threats are routinely criminal, right? If you threaten the president of the United States with intent, that's a criminal infraction. So it can be criminal. You bet your ass. 100%. Yeah. 100%. No problem. In any event, Louisiana's weird. Yes, but they're still subject to the First Amendment. That's the thing. Louisiana isn't only the example, by the way. It's just the one that came first to mind. There's probably other states too. Louisiana was just the one that came to mind. But Louisiana is subject to the same First Amendment that every other state is. So if it's legal in Louisiana, if it is legal for Louisiana to pass a law criminalizing slander, if that's legal, it's legal for every state because they're all subject to the same First Amendment because the First Amendment means the same thing. So if Louisiana's version complies with the First Amendment, then it must be correct in every state. The fact that Louisiana did it is neither here nor there. Louisiana doesn't have any magical power any more than Hawaii does when it comes to the Second Amendment. Hawaii tried to do some bullshit. It was illegal because it's illegal everywhere. Louisiana is trying to do some bullshit, but it's legal. So it must be legal everywhere. That's how it goes. Yeah. This is fun. I appreciate this discussion. In any event, Hawaii also relied on 1865 Louisiana statute enacted as part of the notorious Black Code to disarm blacks. This is always my favorite discussion of a lot of these gun control laws. I really love the irony of these parts of the Second Amendment laws or the Second Amendment discussions so much when the left does it. This is always endlessly hilarious to me. I love it so very much when the left, because it's always the left who does this. You'll never find a right-wing person to do this, I'm sure. There might be an exception, but let's not know true Scotsman this, right? But in any event, it's predominantly the left who will do this, right? They're going to go into court and be like, we get to restrict guns. And the courts ask them why. And they're like, well, during the Jim Crow era, we disarmed blacks all the time. They do it all the time. They do it all the time, right? We have a proud tradition in our state of disarming the blacks. We don't like it when those people, what do you mean by those people? You know exactly what I mean by those people. We don't like it when those people carry or have guns. You know, we're going to pass laws specifically directly designed to prevent those blacks from having guns. And we have a proud tradition in our state of doing that. So we get to keep doing it because racism. That is a fun argument every time. You gotta just love it. You gotta love it. We get to disarm people because of racism. You gotta love that argument. It's just fun because it's so stupid. As the court laid out in McDonald, the right to keep and bear arms was crucially important for vulnerable blacks during this period. That's one way of putting it. Yes. You know, geez, what I can't quite remember. Oh, geez, my knowledge of American history is a little fuzzy, guys. I can't quite remember. Maybe you guys can refresh my memory. What happened when states disarmed black people? Did it end well for the black people? Did it end well for them? I'm having trouble remembering. I mean, I grew up in South Carolina, which, you know, started a minor conflict in April 1861. Barely worth talking about, don't you know? Did it end well for black people when they disarmed them? Did it go super duper well? How'd that go? Anyone remember? I forget. This was well understood by Republicans in Congress who were responsible for the drafting, approving, and securing the 14th Amendment. Against this history, Hawaii claims that this tainted artifact from the Louisiana Black Code, did they literally call it the Black Code? Did they really literally call it the Black Code? They probably did. That's hilarious, too. Illuminates the original understanding of the right to keep and bear arms cannot be taken seriously. And even setting aside the statute's pedigree, it carries no weight because it's neither widespread nor accepted. All right. Should we read Kagan, Jackson, and Sotomayor's dissents? Should we read from the left-leaning parts of the bench so we can understand why the historical racism is a good thing? Let's read some of the dissent because it will be funny and hilarious. We'll just speed read it. We won't read it verbatim, but we'll just read the highlights. Let me just skip to the right part of the opinion. Concurring. Still concurring. Barrett wrote a concurring opinion. How nice. Justice Kagan. All right, what Justice Kagan have to say? She's an intellectual. I would uphold the Hawaii law because, as Justice Jackson shows in part 3 of her opinion, it's a modern-day analog of colonial and founding-era laws that similarly prohibited carrying firearms on a private property without an affirmative consent. The how is identical. The new law, just like the old one, set a default rule against gun carry that a private landowner may reverse. The why is sufficiently close. Both set of laws respond to dangers and harms that someone with a gun can cause. Those old laws had specials, but by no means exclusive concern with poaching. Okay. That the laws had a special, though by no means exclusive concern with poaching, does not matter. I don't know, it feels like it matters. I mean, if it was tied to poaching, that feels like a thing. The regulatory challenges posed by firearms today are not always the same ones that preoccupied earlier generations. That's true as far as it goes. You don't need identical, just analogous. The key question is whether the challenge regulation is consistent with the principles that underpin our regulatory tradition. Here, the challenge law is consistent with the principle because it reflects, as the old law did, that perceived abuses, damages, and inconveniences caused by carrying guns on other people's lands. That is so generalized as to be laughable. I therefore dissent. Well, that was incredibly persuasive. That was just the most round of applause for Justice Kagan just doing the intellectual heavy work there, in not even a full page, once you take away the header, not even a full page, explaining to us why the law was bad. Why even bother writing it? Why not just join Justice Jackson's opinion? Why even bother writing your page? I don't know. All right, maybe Justice Jackson has a more intellectual argument. Sure, let's go with that premise. Today, the court declares unconstitutional Hawaii's efforts to protect the rights of residents, both those who wish to carry guns and those who prefer guns. Okay, right away, I'm having a tough time. I didn't even make it fully into the sentence. I noped out halfway through the first sentence. That's how bad it got, guys. I said maybe Justice Jackson had an intellectual point, and I didn't make it all the way through the first sentence. All right. Justice Jackson writes, today the court declares unconstitutional Hawaii's efforts to protect the rights of its residents, both those who wish to carry guns, ... How did the courts declare unconstitutional the rights of the people who wish to carry guns? What? To hear the majority tell it, Hawaii's law is a blatant attempt to end run our Second Amendment precedent. But the statute at issue does no such thing. Instead, it fairly applies a first principle of property law, the right to exclude, and does no harm to the Second Amendment. No, you still have the right to exclude. You can put up a sign that says no guns allowed here. You can still do that. Your property rights are not. No. The majority thinks otherwise. It reaches today's result by purporting to apply the test we established in Bruin. But the majority gets both the Bruin and its application wrong. Hawaii's law does not implicate the Second Amendment because there's no right to carry a gun onto private property without consent, and the Constitution does not dictate the form of that required consent. Well, that's true as far as that goes. And even if the Second Amendment were implicated, Hawaii has proffered ample analogs demonstrating a history and tradition of states protecting their residents' property rights by requiring those who wish to carry guns onto private property to get express consent. For what it's worth, I think Bruin was wrongly decided. No shit. But even if it's going to be our precedent, the majority should at least endeavor to apply it faithfully. I don't know. I think they're doing okay. I respectfully dissent because the majority has failed to do so here, and its analysis and conclusion only further binds the hands of moderate legislatures. Oh, apologize. Modern. I thought that said moderate, and I was about to lose my shit. I was like, Hawaii is moderate? Holy shit. No, it says modern. I'm sorry. That was my fault. Attempt to balance and protect their residents' interests. With this decision, the court has now manipulated Bruin into a free-for-all that lets the judiciary thwart the will of the legislature by privileging access to firearms above all else. Okay. Can we think of any reasons from the Constitution why firearms might be treated differently than other things? Let's suppose that you wanted to carry into a convenience store. I don't know. How about a cell phone? Can we think of any reasons that we might treat firearms differently than cell phones when it comes to the Constitution? Can we think of any constitutional hooks by which firearms should be treated as special or afforded a different class of protection? Can we think of any reasons from the Constitution in which firearms might in your vernacular be privileged? Can we think of anything in which they might be afforded a special status or special consideration, different and apart from like what color shirt you're wearing maybe, or whether or not the businesses allows you to wear shorts versus pants, or whether or not it requires you to wear a belt? Can we think of any reasons that firearms might be afforded some sort of distinct or special status that might require some special consideration? Can anyone think of any constitutional hooks that might suggest that firearms should be taken in a slightly different thought? No one can think of anything? Neither can I. Help me. Since its time as a sovereign kingdom, Hawaii has never permitted the widespread carrying of firearms in its territory. In 1883, King Kamehameha III of the Kingdom of Hawaii, I don't even know where to start. I can't do it. I can't do it. I can't do it. Yeah. At one time, Hawaii was a kingdom and had a king and stuff. That's true. Can we think of any superseding events that occurred that might in some way disrupt the previous legal order? Can we think of what events might have happened with respect to Hawaii that might make what the king determined in 1833 perhaps no longer the supreme law of the land? Can anyone think of anything? Can anyone think of anything that happened in Hawaii since 1833? I mean, normally the king is supreme. I mean, we certainly understand that, right? The king is the supreme law, right? Normally we can understand that concept. That's not hard. Can we think of anything that happened since 1833 that might have stopped the king from being the supreme law of the land? Can anyone think of a new law that might be, for example, the supreme law of the land of Hawaii? Anyone have any ideas of what the new supreme law with respect to Hawaii might be? Anyone? Okay, moving on. Hawaii maintained this tradition of strict regulation, both before and after it was annexed. In 1927, Hawaii began regulating firearms in particular by carefully controlling who can carry them. Such regulation continued even after statehood in 1959. Oh, that happened. That's right. When Hawaii began allowing private gun ownership, but only if the applicant could show an exceptional case. Thus, the history of the Hawaiian Islands does not include a society where armed people move about the community. That is just so wrong on so many levels. That's just wrong. That's wrong. It's wrong, and it hurts because of how wrong it is. I can't even. All right, when we do the history and tradition test, you know what we're not doing? The history and tradition of Hawaii. Nor, for that matter, the history and tradition of, for just random examples, California or Utah or Texas or Florida or New York or New Jersey as such. You know what we're doing when we do the history and tradition test of the Second Amendment? The common law. Right, the common law, which largely precedes the United States. Not entirely, but significantly. It's the right, the pre-existing one, the one that existed before. Where did this pre-existing right come from? I'm so glad you asked. The United Kingdom. That's where the common law is. Didn't you know that? Didn't you know that's where the common law comes from? Did you not know that the common law comes from the United Kingdom? I'm happy to help you learn this shocking reality. So we're not really interested in the history and tradition of Hawaii. We're interested in the history and tradition of, the common law since around the 12th century. Give or take. God help me. That custom continued until very recently. Yes, because the Supreme Court finally decided the Second Amendment existed. I mean, to be fair, it took them until the late 1930s to start figuring out the First Amendment existed. So it took them until the 30s, really later than that, to be honest. But around late 1930, the Supreme Court discovered that there's this thing called the First Amendment, and it might, in some ways, potentially, mean something. I know, it was a shocker. They finally got that far on the page. It took them a little bit longer to get to the Second Amendment. But yeah. Okay. That custom continued to recently. Prior to this decision in Bruin, which permitted concealed carry only in exceptional cases, blah, blah, blah. The result, Hawaiians have rarely carried or others carrying guns. Sure. Which was true of many states in this country, especially before Florida revolutionized the concealed carry revolution in, what year was that? And who was it? It was a female. What was her name? I should know her name. God, why can't I remember her name? I used to be an expert on these things because I used to be a legal advisor for a Second Amendment group, and I used to know these things cold. But I haven't been a legal advisor for a Second Amendment group in a while, and I forgot these things. Who was it? It was like 1987, 89. What was her name? Marion Hammer. Wasn't that her name? Marion Hammer? I think it was her name. I think I remember. Wasn't it Marion Hammer, circa 1989, who, basically said, what would be interesting? What if we had it like, concealed carry laws in Florida? And then basically it took off after that. Yeah, basically Marion Hammer invented it. And then, we kind of decided it was a good thing in this country. Yeah. Anyways, pressing on. Following Bruin's rejection of licensing schemes like Hawaii's, the state was forced to alter its longstanding tradition. To accomplish that, it enacted Act 52, which allowed for concealed carry permits to issue, technically, One problem as Hawaii confronted as it undertook how to best protect Hawaiians who, accustomed to traditional practice, might not be aware that gun laws were changing and allowed to be armed and concealed carry in everyday life. In particular, given Hawaii's history, private property owners were unlikely to expect guns to be carried on their property and know that they needed to take steps that didn't wish to permit armed entry. Well, you could have just sent out a memo. If you're the state of Hawaii and genuinely believe that people don't know this, you could buy some advertising and maybe put up some billboards. You could send maybe every business in the state a fucking letter. If you're concerned about Hawaiians not knowing this, you could educate them. I swear, it is possible to get the message out to the great people of Hawaii. Okay, the great people of Hawaii are not idiots, and they're not dullards, and you can in fact send them a letter or maybe an ad campaign, maybe some billboards or something, and you can educate them. Hawaii, you can do this, I swear. The community was up in arms about this, so to speak. Is it legal to suggest punching a Supreme Court justice in the face, asking for a friend? All right, moving on. Hawaii's legislature held hearings and received testimony from residents and the business community indicating that private property owners did not want people carrying guns on their property without their express consent. This input from Hawaii residents mirrored evidence from around the country. One nationwide study revealed widespread public misunderstanding about whether it was lawful to bring a gun onto private property. Again, there are ways to solve this problem, Hawaii. I'm sure you can figure it out. Not only that, but the study respondents generally had preferences against armed carry in certain spaces, even spaces open to the public. That's super interesting and all, but the Second Amendment's not a popularity contest. A straightforward solution emerged. At 52 would be required to gun. You got to just appreciate the comedy of this, guys. I mean, I like to think that I'm a reasonably funny guy. I'm not a stand-up by any means, but I'd like to think I've got some comedy chops. But I cannot write things this funny. I just don't have it. I mean, I understand my own limitations. As a writer and a creator, I'd like to think I can throw in a joke once in a while, but I am just not capable of writing anything that's hilarious. This is great. This is amazing. The comedy value is off the charts, man. Hawaii codified this affirmative consent solution, prohibiting a concealed carry permit holder from carrying a handgun onto private property unless the permit holder has been given express authorization by the owner. By the way, could I be so bold at this point to suggest maybe some super chats or some things I'd like to just say thanks to It's Me, Tony, for the 10 gift memberships, Rowan Cowart for the becoming uncivilian, Blackbird for being a member for 65 months, Michael Carter for being a member 13 months, and Kiska for being a member 28 months. Could we get a few more super chats and memberships this way? It would be appreciated. I'm not beyond asking. Hawaii codified this affirmative consent solution, prohibiting concealed carry holder, thank you, Jeff, has been given express authorization to carry a firearm on the property by a lease owner, blah, blah, blah. Under the relevant law, such express authorization could either be by unambiguous written or verbal authorization or by the posting of signage, thus help narrow the informational asymmetry. Again, there are better ways of solving this problem. Indeed, the enacted law stated that the legislature had adopted the law to respect the right of private individuals and entities to choose for themselves, which they still can, and to promote public health. Thank you very much, Christy, for the 10 gift memberships. Notably, in making this choice, Hawaii was not alone. Thank you, W.M. Luke Priest, for the 10 gift memberships. It joined 4 other states that had similar laws. Petitioners believe that having to ask for permission to carry a firearm is unconstitutional burden, but their bid to invoke the Constitution stumbles out of the gate. At step 1 of the court's test, there is no constitutional right to enter private property without the owner's permission, let alone a firearm. Okay, that's true, but the point isn't whether or not you have the right. The point is whether the government can impose this right? So the private property owner still has the power. It's about the government, not about the private property owner. Yeah, Z Brown says, can we dress up Curtis Jackson and then covertly replace? The problem is, even if you somehow could get me to pass as Justice Jackson, I can't write like this. I don't have it. I can't write like this. I think people might notice. Oh, Lord. Skeeve Man for £5 says, thank you, Kurt, for keeping your mind out of what's under my kilt. For the benefit of doubt, there's not much like the minds of some judges. To avoid the obvious outcome, the majority has to reconceptualize Bruin, do they? Instead of applying a threshold criterion, who taught her that word, asking whether challenges have shown up the plain text of the Second Amendment, which codified a pre-existing right to carry, covers conduct that challenged law restricts, the majority essentially directs courts to start asking simply whether a gun owner cannot do what she wants with the firearm. The majority thereby eliminates step one effectiveness as a means of identifying gun-related laws that impinge on the rights secured by the Second Amendment. That move represents a significant expansion that, as applied here, obscures what Bruin actually, step one, reveals. The case is about property rights, not gun rights. Uh-huh. Our law holds the property of every man so sacred that no man can set foot upon his neighbor's clothes without his leave. If she knows what clothes means in that sentence, Lord. This principle, called the right to exclude, is the sine qua non of property. It's one of the most essential sticks in the bundle of rights. It's one of the, what do we call a bundle of sticks? Lol. That are commonly characterized as property, then universally held to a fundamental element of property law. Simply stated, the right to exclude means that members of the public may not privately own property without the consent of the owner. Do so would be trespass. Wow, that's amazing. And the license is a privilege, revocable at the will. That's true. The consent establishing a license to enter someone else's property can be explicit or implicit. True. The form of consent typically depends on the nature of the property. True. In many places, private property owners welcome visitors. Thus, as a majority note, the public generally enjoys an implied license to enter this sort of property. That is, the private property open to the public. Yes, when you open a business open to the public, amazingly enough, the public thinks they can go there in order to conduct business. I know, it's amazing. The scope of any license to enter can vary in ways that are relevant here. First, as courts have traditionally. Dogs in restaurants provide an example. I'm about to lose some brain cells right now. I can feel it coming. Dogs in restaurants provide one modern example. In the absence of a regulation saying dogs are not permitted in restaurants, the implied license for a human customer to enter a restaurant might extend to a pet, or it might not. But either way, a property owner has the option to put up a no dogs allowed sign to make it clear dogs are not welcome. Yeah, Jeff DG asks the relevant question here. It's like, again, can you think of any reasons based on the Constitution? Can you think of any reasons? Right? Because after all, we do have an equal protection clause. Right? We do have an equal protection clause, so let's give the equal protection clause its due, right? We need to treat equal protection requires us to treat similar things similarly, right? We have to have a reason to treat different things differently. Cool. All right. So let's suppose as your dictator from on high, I will declare that dogs and guns are otherwise identical. They're the same thing, ma'am. They're categorically the same. Okay, this isn't even close to true. But let's just pretend you and I together, we're a team, right? We're going to pretend the dogs and guns there's no distinction between them as far as equal protection goes. Okay, so geez, man, I would you know what? As a government, I'd really like to do. I'd really like to pass a law that bans dogs and bans guns because they're categorically the same, don't you know? Okay. Can we think of any reason any reason from the Constitution that they might not be the same? Can we think of any other provisions of the Constitution that might suggest that maybe perhaps firearms in some way should be treated as distinct? I know that by all rational and common sense metrics, guns and dogs are exactly the same. I appreciate that. I need you to go into a deep place in your mind and just pretend that they're not. Can you think of any reason that guns and dogs should be treated as different based on the Constitution? You got any constitutional hooks? You got any of those constitutional hooks you can inject into my veins? Help me. Please help me. Consider, for instance, do I have to? Okay, this is actually a sentence that a Supreme Court justice just wrote. So we're going to do this together, you and I. We're actually going to do this in real time, okay? I want you to wipe your mind clean because we're going to do a thought experiment. The Supreme Court would like us to do a thought experiment, so we're going to do it, you and I, okay? Wipe your mind clean, let's do it together. Consider, for instance, a case involving button makers who had entered a plaintiff's private land in search of mussel shells. Yes, profound. Gene Angry Penguin for $5 says, I don't think Jackson has considered some of the historical practices of our list savory native tribes. Legalized long pork? Cute. In many places, that entry might have been a trespass. But in Missouri, where mussel hunting took place, there was evidence the practice of permitting people to enter private lands to hunt had prevailed, and the local custom had mattered. The court explained that English common law must be taken to mitigate by the practice that had prevailed in the region where the suit originated. When it comes to hunting mussel shells, presupposing they're identical for equal protection purposes, can we think of any other constitutional hooks that might suggest mussel shells and firearms should be... No, okay. In other words, there was evidence that local custom had developed such that mussel hunters might have an implied license to enter the land. The rules governing a license, therefore, are not universal. Second, because states have the power to set default consent rules, state law can alter the scope of a license. For example, the English rule was that the public had to obtain an owner's express permission to hunt or fish on unenclosed private property. That sounds a little bit like poaching to me, but never mind. But some states altered that rule. In all events, uniformity with respect to the scope of licenses to enter private property was never thought necessary or even desirable. Instead, local inhabitants molded licenses to fit local needs both by custom and positive law. You know, that is actually true as far as it goes. It is true as far as it goes, right? When we think about what an implied license is with respect to property, that can and does vary based on locality. It's true, and custom. That's true enough. There are distinctions in places about what is considered proper and what's not considered proper with respect to particular kinds of businesses. When I walk into a business, what can I do while I'm in there? Might be determined by the nature of the business. For example, if I'm entering a business run by the Amish, that might have different customs than with respect to, I don't know, a business in New York City. I wouldn't know, I'm not an expert, but I would presuppose there might be some distinctions. And what is considered, cool and appropriate in New York City might, not necessarily be considered cool and appropriate in Amish country, general store. Again, can we think of anything at all that might suggest that guns should have a privileged or protected status? All this makes clear that Hawaii does not restrict the right to carry a gun at all. Well, I'm sold. I've changed my mind. I've changed my mind. I was under the impression this entire time that Hawaii's law, in some sense, restricted the right to carry a gun. But it doesn't. It doesn't at all. We've all been wrong, man. I mean, again, it's been a long time. Again, earlier in my career, and it's been a while, I was, a legal advisor for more than one gun group, actually. I was a legal advisor for 2 different gun groups. I used to be very, very knowledgeable in the Second Amendment, and I still am, but, I'm rusty because I haven't done it as much as I used to. But, I still can carry a conversation. I used to be an expert, maybe less so now, but even the experts get it wrong sometimes. After all, this law does not restrict the right to carry at all. I feel so much more enlightened. Instead of the law vindicating a private person's rights by operating the scope of the implied rights to enter, and it does so by requiring gun owners to seek express consent rather than assuming implied consent. Consequently, Hawaii's law does not implicate the Second Amendment. Bruin instructs the courts must start by asking where the Second Amendment's plain text covers an individual conduct. But like most rights, this is one of my least favorite lines. This is one of my least favorite lines because it's true, but the left and the progressives massively and purposefully misquote it, right? Because it is true. The Second Amendment, like the First Amendment, is not unlimited. It has limits. More to the point, I would say borders, but whatever. A border is just a limit. So whether you call it a limit or call it a border, we're kind of talking about the same thing. It is true the Second Amendment is not unlimited. It does have limits or borders, if you prefer, as I do. But to say that it has limits doesn't mean that anything you want to do is okay, which the progressives constantly say, right? The progressives constantly want to say, well, it's not unlimited, which it's not. Therefore, I can do whatever I want. That's nonsense. In the same sense, it's true in the First Amendment. Is the First Amendment unlimited? Of course not. Does that mean that any regulation you want to pass on the First Amendment is therefore lawful? Of course not. That's some bullshit. But when it comes to the Second Amendment, they haven't picked up that lesson, and they constantly throw this line back in my face and it's really fucking annoying. The Second Amendment codified a pre-existing right, and pre-existing limits on that right are part and parcel of that. That I agree with wholeheartedly. 100% I agree with that. The Second Amendment is a pre-existing right. It's the right. It didn't create something new. It recognized something that existed. Pre-existing limits, or if you prefer, pre-existing boundaries, are in fact part and parcel. The Second Amendment is limited by its own scope. That has to be properly understood. It does not mean the right to bear, it does not mean the right to keep, nor the right to bear any arm you want under any circumstances or means or method or blah, blah, blah. It is narrower than that. What it means is a whole constitutional seminar. So Bruin's much like it would mean in the First Amendment. Like, this is what I like, right? When people say, okay, this is the part I really like as a legal educator. When people say, okay, what does arms mean in the Second Amendment then? And I'm like, are you out of your mind? I mean, I appreciate the question, but like, are you out of your mind? That's like asking me, what does speech mean within the context of the First Amendment? How much time do you have? How much time do you have? Your question is deceptively simple. What is arms then in the Second Amendment? It would be exactly like asking me, what is speech then in the First Amendment? How many days do you have? Weeks. It's gonna take a hot minute. Holy shit. Kill me. Hope my day is going well. Well, I'm losing brain cells as we speak. Better than that, yeah, it's going fine. Here are the pre-existing limits doom petitioner's case. Petitioners wish to carry onto private property without seeking express consent. Yet everyone agrees that consent is a precondition. Kill me. That concession gives away the game away. No, it doesn't. The relevant law does not burden petitioners' right under the Second Amendment because there's no right to carry a gun on private property without permission. The right excludes a wrong recognized pre-existing right. To be sure, the public may well have an implied right license to enter public private property, and such permission might generally include the ability to enter armed. But as I've explained, any such license is not a matter of right. A license is a creature of state law. Typically, that's true. Can we think of any? Yes. Private property and the rights thereto are typically defined by state law. It is within the sovereign domain of the state to define. Can we think of any constitutional hooks at all that might impact that understanding to any degree, particularly when it comes to governmental action, when it comes to the states using state authority to pass a law with respect to private property? Can we think of any constitutional hooks that might inhibit the otherwise sovereign right of the state to do as it please? Anything at all? Unsurprisingly, then, there are multiple historical examples of states altering the scope of implied licenses through legislation. Under the common law of England, there was no implied license for a person's livestock. Okay, my God. My brain cells. Under the common law of England, there was no implied license for a person's livestock to enter another person's unfenced land. But colonists reversed that rule through legislation requiring landowners to fence out roaming livestock they didn't want on their property. Suicide is painless, brings on many changes. I could take or leave it as I please. And it's not just livestock. Oh, good. States have also historically altered the scope of implied license to carry firearms on private property. During the founding era, multiple states passed laws that operated on the interaction between armed carry and the right to exclude. Those laws, like Hawaii's, required affirmative consent for armed entry. Thus, at presumably relevant historical time periods, it was commonly understood the right enshrined the Second Amendment yields to property rights when where private property is concerned. Entry was, in the first instance, subject to the right to exclude, and because the state law and custom set the bounds of the right to exclude, the scope of one's ability to carry firearms on private property open to the public, and the form of consent required was likewise changeable by custom or state law. This was the backdrop of the Second Amendment. The right to enshrine did not protect an unyielding liberty to carry guns on a private property. In other words, the conduct here, carrying guns without securing property owner's consent, is not part of the Second Amendment, and I've lost the will to live, and I can't read anymore. I made it as long as I could. I need a quick mental reset. Oh, God. Okay, let's talk more about Mullin versus Doe. In Mullin versus Doe, at some point, the administration declared that Haiti... Heartbreaker. We're on to the TPS opinion. We're here. You mean the dissent? Oh, Lord have mercy. I don't know if I'm in for it, but yeah, fine. We're in for the TPS opinion right now. So Syria and Haiti at some point basically received a status saying that they were like, you know, really bad places and we're going to grant refugee status to them. And then at some point, the administration said not so much anymore. Okay. So in any case, what happened? The TPS statute bars judicial review of non-constitutional claims. The relevant law provides that there is no judicial review of any determination of the Secretary of Homeland Security with respect to designation or termination or extension of the designation of a foreign state. The term determination means either the decision or the process. Under either understanding, the relevant law bars the non-constitutional claims. Further, with respect to, generally has a broadening effect, ensuring the scope of the provision covers not only the subject, but matters related to the subject. Respondents in the court below offer no sound theories to overcome the plain meaning of the judicial review bar. Respondents' argument that the relevant law applies only to substantive claims, not those barred based on allegedly procedural errors, finds no support in the language because determination may concern procedural or substantive claims. Respondents' reliance on various law is misplaced because those decisions turned on specific wording of different provisions and did not adopt the broad principle that determination applies only to substantive matters. Doe responds arguments that determination refers only to assessment of a country's conditions, finds no support in the statute's text or context, and contravenes the principle we give common terms their ordinary meaning. Response attempt to limit the judicial review bar to the Secretary's ultimate determination, not a subsidiary decision, is inconsistent with the plain meaning of the statute and contradicts the administrative law principle that subsidiary decisions merge into the final agency action, which is correct. Right? When we're talking about the agency, we mean its final determination. That's what we mean. The relevant law responds, or the Myatt respondents' equal protection claim that Hawaii's TPS designation was terminated because of race is unlikely to succeed. Ironically, respondents themselves offer race-neutral explanations for government action, namely that the current administration wishes to terminate every TPS designation that's come up for review, simply opposes the TPS program as it's been implemented. The court determines for the sake of argument that the heightened scrutiny applies. For race, sure. It must determine whether discriminatory purpose was a motivating factor to terminate the TPS designation. Fair enough. Because application of that standard calls for consideration of the context in which the challenge statement was made, the immigration context is an important factor. None of the cited statements by either president or secretary was overtly racial, and in substance, all expressed policy views that could rest on racial neutral qualifications. Viewing all relevant evidence, the Myatt respondents are unlikely to prove race was a motivating factor, and it follows they're not entitled to interim relief. Okay, I have no problem with that. Should we read some dissents? Should we read some dissent from Justice Kagan, who is the smart one of the bunch? So maybe Justice Kagan has some good points. I don't always agree with her, to be sure, but, you know, she's usually, but not always, thoughtful. So what does Justice Kagan have to say against this proposition? Let's see. All right, let's see what we got. For over a decade, the government has provided humanitarian relief to Haiti and Syria in the United States through the Temporary Protected Status Program. The Secretary of Homeland Security first designated Haiti for the program in 2010. The Secretary designated Syria in 2012. Since those initial designations, secretaries have repeatedly examined conditions and repeatedly determined that they remain too dangerous to permit safe return. As a result, those countries' designations have been extended year after year, and hundreds of thousands of Haitians and Syrians have been able to work and live here. But that's no longer so, and the suits before us challenge that change. Last year, the then Secretary, Kristi Noem, at the instigation of President Trump, terminated Haiti and Syria, declaring both countries now safe. Haiti and Syria's holders brought these cases and sought interim relief. District Court granted that relief, finding the terminations were likely unlawful. Both courts concluded the Secretary probably violated the statute by ordering the terminations without first consulting with other agencies about current country conditions. And the District Court in Haiti found as well that plaintiffs had likely successful equal protection claims. And because statements made by a president show a racially discriminatory purpose. Today, the court undoes that preliminary relief, insisting that terminations take effect now based on two mistakes about plaintiff's likelihood of success. First, the majority asserts the Secretary's compliance with the TPS statute is in every respect unreviewable by the courts, pretty much. But in fact, the statute allows judicial review of whether the Secretary adhered to the procedures it mandates, which the plaintiffs dispute here. Secondly, the majority claims it sees no evidence that race played any role. But the evidence is there, plain to see that present statements, which a majority and for that matter his own lawyers can even bear to repeat. Once that much is established, the case for interim relief is made. There's no dispute that the plaintiffs will suffer irreparable harm absent postponement. So the plaintiffs are entitled to stay in this court. Respectfully, I dissent. Okay, so far so good. Start with how TPS works. The governing statute authorizes the Secretary to designate a country for a program if it suffers from dangerous harms. When the Secretary makes that designation, they announce how long it will last. At the end of that period, the designation does not go away, nor is its fate left to the Secretary's unfettered discretion. Rather, the statute mandates a periodic review process. At least 60 days before the end of the chosen period, the Secretary, after consultation with the appropriate agencies, shall review the conditions in the foreign state and shall determine whether conditions for such designations are met. If the Secretary determines the statutory criteria are no longer met, they shall terminate the designation. Either way, the Secretary shall provide for on a timely basis for publication and notice. So in all, the statute tells the Secretary to complete 4 steps: consult, review, determine, and publish. The first question in this case is whether the federal court can review a claim. The Secretary failed to take one of the 4 mandated steps. Here, that before terminating, they failed to consult with appropriate agencies. The plaintiff's failure to consult claims are brought under the Administrative Procedures Act, which means judicial review is available unless a relevant statute precludes it, or a challenge action is committed to an agency discretion. That's correct. Neither the government nor majority contends the actions in dispute are committed to the agency's discretion. Okay, so the issue here is where the TPS statute prevents court from reviewing the Secretary's compliance with mandatory procedures. The statute does no such thing. Its judicial review bar applies not to everything the Secretary does under law, but only to the determination with respect to designation or termination. Well, if that's true, then I'm not sure really anything else matters at that point. Like if we can't review the determination itself, can you really review the process to get there? I mean, that seems slightly odd. Does the Supreme Court see each other every day? Well, we don't know exactly how it works, but to answer your question, yes. They spend a lot of time in chambers writing and thinking and reading, but yes, they talk to each other. They pass memos with each other, they email each other, they have lunch together. So yes, in both formal and informal sense, the Supreme Court talks amongst themselves essentially every day. The amount of live chat has gone way down, I see. The chat rate has basically gone to 0. So maybe people are not excited about this case because no one's interested in talking about it. When we talked about the gun case, chat rate was great, but no one cares about this case. So maybe we'll talk about something else and see if there's something else you guys care about more. Let's see what else is going on then. Okay. Let's discuss whether a person arriving on the Mexican side of the line is arriving in the United States. All right, so this is Mullin versus Otro, Lado. A bunch of aliens arrived at the border, but were on the Mexican side of the border. Does that count as being in the United States? An alien standing in Mexico does not arrive in the United States by attempting and failing to set foot in this country. An alien arrives in the United States. Well, let's read the decision. Jackson filed a dissent. let's read Jackson's dissent. Jackson dissents alone. Oh no, Sotomayor filed a dissent, and Jackson also dissented. Let's see what Jackson wrote by herself in dissent. Now, for what it's worth, let's read Sotomayor, because I'm partial, or at least I'm more willing to accept the dissent's ideas here. So let's see if they can convince me that they're right, because I think that there's a case to be made. So let's see if the dissent can persuade me they're correct. Which, to do that, I understand the majority decision. It's just literally reading the words on the page, it seems to me. So let's see what the dissent has to say. Since 1917, Congress has required immigration officers to inspect non-citizens who arrive at port of entry to determine whether they may enter. Since 1980, Congress has allowed non-citizens who are fleeing persecution to apply for asylum as part of the inspection process. Congressional statutes lay out a mandatory set of procedures to guide this process. A non-citizen who arrives in the United States, whether or not at a designated port of arrival, and seeks admission shall be inspected. If a non-citizen who's arriving in the United States lacks valid travel documents, an officer shall order removed unless they convey an intention to apply for asylum or fear of prosecution, which in turn requires the officer to refer them for further processing. This system is designed to ensure the government processes each person who comes into the United States to determine who should be allowed in. The court today holds the executive branch may circumvent all these mandatory procedures by having U.S. immigration officers stand at the border and physically block non-citizens. There is something a little bit off about that, in my view. They may do so even if the asylum seeker is at the threshold of the point of entry designed to receive all non-citizens. Even if the point of entry has ample capacity to inspect that person, including an available asylum officer, if the asylum seeker is certain to be prosecuted, killed, or turned away. The court's illogical interpretation is driven almost entirely by fixation on a single word, in. Words, however, must be read in context, with attention to how they fit into statute as a whole. The majority ignores the statutory context and history, not to mention law and standing position of the executive branch, all which shows that any non-citizen arriving at our doorstep and seeking admission must be inspected and allowed to apply for asylum, regardless of whether their foot has crossed the threshold. I mean, that is what Tom Mullin himself said in Congress way back when, right? When AOC was questioning Tom Holland. Remember that from way back when? AOC was questioning Tom Holland, and Tom Holland said that they could apply for a point of entry. And now the government's saying, well, not so much unless you actually cross over, which seems odd. Because the court blesses the executive decision to slam the door on all those who flee prosecution, despite detailed inspection in the asylum system, I dissent. Yeah. A proper understanding of this case requires reality of challenge metering policy. The United States is dotted with designated points of entry. Over 20 points of entry are designated as Class A, meaning they're designated to process all aliens applying for admission. These points abort the butter and include vehicle lanes, pedestrian walkways, and arrival hall, all staffed with custom and border. Where the Rio Grande marks the border between two countries, arrival halls are generally at the north end of the bridge, spanning the river, with the border marked by a plaque on the bridge near the midway point. At land portions of the border is marked by turnstiles on the road leading to the arrival hall. Before 2016, pedestrians seeking asylum at the point of entry, like any other traveler seeking to enter the United States, would typically pass into United States territory by bridge, arrive at the rental hall, and walk up to one's several desk. An officer would then review their travel documents, a process known as inspection, and admit them or send them to another area. For example, a pedestrian with a valid visa might be admitted immediately, while a pedestrian without might be referred to further inspection under an expedited removal process. During this process, pedestrians could also ask to fill out an asylum application would be forwarded to an inspection area. In May 2016, this process began to change, initially responding to a surge of increased migration arrival at a single port of entry. Border Patrol officials at that facility for the first time instructed arriving migrants to turn back to Mexico, return to the point at certain times for appointment. Soon, though, this metering system spread to other points of entry along the southern border, with officials turning away all individuals without valid documents, but now without identifying any future time. In an early period of metering, $5 from Neutral Robinson. Listening while I do legal research, and I can't help but waiting to die every time Justice Jackson writes something. You are welcome. Thank you. Instead, the Border Patrol began directing officials to block asylum seekers. Gradually, the government formalized the system into metering. First, in 2016, the Department of Homeland Security approved of the practice and authorized ports of entry to implement metering based on where works operated and whether it was required on any day. Then informal guidance, CBP authorized officials to authorize the entire border and meter the flow, meaning they could operate at physical controls and may not provide tickets or appointments. Stated point was resources. Over time, however, it became clear that metering policy had little to do with capacity. Yeah. According to the point of entry, lacked capacity is justification for metering regardless of point's actual capacity. For some ports, detention facilities were completely empty 80% of the time. Still, as a whistleblower would later testify, officials were instructed to lie to people by telling them they were at capacity and send them back. Yeah, that doesn't sound good to me. Soon the metering policy created dire human consequences, blah, blah, blah. Despite these conditions, some attempt to read the soil by other means, blah, blah, blah. Circumstances brought APA, Ninth Circuit agreed. Implication decision, the question before the court requires the government to inspect and provide asylum application non-citizens who arrive at point of entries. Majority in this conclusion focuses almost exclusively on the word in. If that were all the case we're about, the majority might have the better of the argument. Statutory interpretation, however, requires more. It's fundamental canon of statutory instruction that words of statute must be read in context and with a view of the place of our overall scheme. Properly read in context, the phrase arrives in the United States encompasses non-citizens who are in the process of arriving. This construction comports with the plain text of various law. Usage terms arrives, arriving, and neighboring statute provisions, and consistent interpretation. It gives meaning arrives in rather than rendering superfluous or superfluous. Avoids anomalous results. It best accords with statutory and legislative history. Yep. I don't know which way I would have ultimately gone on this decision. I mean, a textualist, which I normally consider myself to be a textualist, would suggest it be read in its literal text. So it would suggest I'm with the majority. But on this occasion, I'm not sure. I think, I don't know which way I would have ultimately gone on this issue if I were on the Supreme Court. I could see myself potentially signing on to the dissent in this case. This, however, has nothing to do with my opinion about asylum practices or the abuse thereof. Because again, I'm just interpreting the law, right? I'm not here to set policy. Do I think that the current policy as depicted in the statutes with respect to asylum is a bit broken? Yeah. But as a court, that's not necessarily my responsibility, right? Congress needs to Congress better. So I think there's a very serious chance I would have wound up in the minority on this case. I don't know which way I ultimately would have gone on this one. It's definitely something I would have had to ponder a lot harder. But I think the minority is making a very reasonable case. The majority interpretation of rise in the United States makes no sense. The majority ignores that arrival and arriving have never focused on precise location of citizens' feet. Majority concentrates on everyday examples arrives in. Majority is right that chosen examples are naturally read to require the person to be physically in space. Terms arriving and arriving in, however, does not always mean it that way. For example, a train conductor announcement, "We're arriving in Penn Station," might mean the train is inside the station or merely that started slowing a half mile away. If someone said, "Call me when you arrive in Washington, D.C.," it would be logical to call them once you landed at the DCA airport just across the river in Virginia. Yeah. Nor would it be premature to say someone arrives in San Francisco while she's still driving on the Golden Gate Bridge. These examples show the meaning of phrases arrives in independent context. A more fitting example might be the following. Imagine a movie theater policy that states anyone who arrives in the theater may buy a ticket and all moviegoers must have their tickets scanned before entering. If a person walks up to a ticket booth located just outside the theater, it'd be unreasonable to think they could not buy a ticket under the policy because they're not in the theater yet. Perhaps the policy should be clearer by using the preposition at, but everyone understands what it means. Yeah, I'm not necessarily opposed to this idea. Isn't she mixing legal and colloquial definitions? No, not really. Yeah, because the question is, what does the word mean and the overall statute? And using these examples to help show what the word means is not inappropriate. And yeah, I don't find it inappropriate. Whether you find it persuasive or not is a whole other set of problems, but I don't find it inappropriate. Next, the majority focuses on the preposition in and surprises the Congress intended to include those reach the board but not yet crossed. We refer to non-citizens arrive at, reach, or at. Other nearby provisions demonstrate that Congress arrives in describes the category of arriving aliens. For example, a different statute governs removal of aliens uses terms interchangeably. Specifies a non-citizen who arrives at the United States and is removed upon arrival shall be returned to the country in which the non-citizen boarded the vessel or aircraft in which the alien arrived in the United States. Yeah, so they mix it within the same section. That provision refers to the same person in both instances, even though one references at and the other uses in. That's a good example. Another example, a different statute provides for expedited removal of non-citizen who's arriving in the United States. Yet, which sets out further expedited procedures, prescribes a person for removing an alien arriving at the port of entry. Yeah, I mean, this is pretty reasonable. Yeah, Charlie, actually, it's a pretty interesting thing you say when you say, like, if I'm standing at your front door, you're not standing in your home. Actually, I'm not sure that's true because there's this idea of curtilage. So is your porch in your home? For Fourth Amendment purposes, yeah. Yeah, is your porch in your home? Yeah. There's definitely non-trivial arguments to be had, man. Yeah, 100%. Curtilage is separate from the home? No, not really. Well, I mean, it has a different term, but it's still treated as the home for the Fourth Amendment purposes. Let me put it to you this way. If I had the right case and the police did something on the curtilage and I wrote that they were in the home, yeah, yeah. I'm saying. Yeah, what does it mean to be in a home? That's an interesting question, right? What does that mean? Does it have what is yeah, it's like these are fun questions. What does it mean? Is a porch in a home? Why or why not? Does it matter if it's fully enclosed or not? Does it matter? Is it suddenly inside the home if if you have a porch where, you know, there's what would you call a balcony when it's not on the first floor? A wall? Like, so you have windows, but no glass, because you could have that, right? You could have that. It's common, like you have like usually like a landing or something of some kind. It's like usually in a porch, it doesn't go all the way down to the foundation, right? Usually there's something built above the foundation, so you have like a wall, I guess. You have a wall, and then you have a gap, and then you've got ceiling, right? That's pretty common, right? Does it matter if that gap is open or if it's encased by a screen, a screen? Does the screen make it inside versus not? If there's a door or not, does that make it inside versus outside? Yeah, these are fun, exciting questions. Is a porch inside the home? Does it matter if it's fully enclosed, partially enclosed, not enclosed at all? What makes it inside or not? Exciting and fun questions had by all. Yeah. If you open the door, are you no longer inside? If you have a sliding door and you open the door, are you no longer inside? What if you just remove the door completely for whatever reason? Is it no longer inside because you removed the door? Fun and exciting questions had by all. Your porch may be inside. Oh, Lord, have times. Good times. This is fun with law. If you open the windows, if you have windows, but you open them, are you no longer inside because there's no longer glass between you? But you could close them, so they're open now. It's like, what are we doing here? This is stupid. Yeah. If I open my balcony, in fact, I'm going to do it just for the hell of it. I'm opening my balcony door. Hold on. One moment. Okay. My balcony door is now open. Therefore, I am now outside. Excellent. Very good. Here, if Congress could have been clear on the words that shows the Congress statute and history plainly shows the Congress phrase in the United States to capture all those who are arriving. There's no way the opening door would simply change inside or outside versus any sane world. I think you're missing the point. Let's suppose you're correct. Merely opening the sliding door doesn't count. What if I just remove the door completely? I could do it. I mean, I've got tools. I'm not sure why I would want to, but I could. What if I remove the door completely? Does that change it? Are you understanding the question I'm actually asking? That's the real thing. Do you understand the question I'm really asking? Here's a hint. It's a little bit deeper than the surface level question. When I say, if I open the door, am I outside? There's a depth to the question. You gotta. Anyways, pressing on. You're not understanding the depth of the question. You're not really understanding the question. You got to go beyond the surface level of the question and look deeper, man. More to the point, what counts as inside versus outside? That's the real question. In case you're curious what the real question I'm asking is, what counts as inside versus outside? How do I know if I'm in a house? If I'm on a porch, what features must the porch have for me to be inside? That's the real question I'm asking. If I'm standing on a porch, what features must the porch have for me to be inside? What distinguishes inside from outside? That's the actual question I'm asking. Lord have mercy. Nothing? It's not inside the home? Really? Even if I fully enclose the porch? With glass? And a locking door, now it's no longer inside? What if I use screens instead of glass? Or I use slots. I don't use screens. What if I use some sort of physical slits? Does that make a difference? Do you understand the real question I'm asking? Some of you are not understanding the real question I'm asking, and it's getting a little bit annoying. The majority right does not dispute the interpretation arrives at as superfluous. Of course, it declined to apply. It's true that there are circumstances where anti-surplus candidates are salient, blah, blah, blah. Hypothetical reason arrives at, blah, blah, blah. Yeah, I'm okay. So Sotomayor is making some points. It becomes a sunroom and not a porch. At what point does it become a sunroom and not a porch? Exactly what is the difference between a sunroom and a porch? Are you sure? You're not, Lord have mercy. You're killing me. I'm dying inside. How enclosed does it have to be? You're not. I'm just going to stop asking questions because you're answering the wrong questions. I'm asking questions and you're answering them literally, and you're not. I'm like, you're not getting it. Oh, Lord. All right, let's see what Justice Jackson had to say. Today, the court issues an advisory opinion on lawfulness of meaning. A policy has not been in place. Since rushed to greenlight this retired practice, the majority elides serious judiciability concerns and decides legal issues entirely in abstract. With potential mootness problems without a factual record establishing how meeting works, the writ of certiorari should never be granted. I respectfully dissent from the unwise decision of plow ahead nevertheless. I'm already tired. She thinks it's moot. She still thinks it's moot. She's arguing over mootness for a while. Blah, blah, blah. Blah, blah, blah. I don't want to decide this case. I don't want to decide this. The court is not a law student puzzling through a difficult cold call. Kill me. Oh, she just doesn't want to rule. She's just salty for the Supreme Court ruling. She has nothing to say about the substance of it. She's just salty that the Supreme Court granted the case. That's exceptionally great. I'm not sure why she's salty about it, incidentally, but she's salty about the court. She's really, really strict on standing doctrine. Yeah, that's definitely something Justice Jackson seems like she would have a real stick up her ass about. She definitely seems like the poster child for standing uber Alice. Yeah, that definitely feels like a Justice Jackson opinion. I really, really care about standing concerns, man. They are front of my mind, man. This far enough. Really? I'm not buying it, man. I don't buy that. I'm not sure what's really going on, but I don't buy that bullshit. Talk amongst yourselves. I require water and or beer. All right. I feel much better now. Excellent. Where were we? Oh, we have the Monsanto case we can talk about. I'm not sure there's really much to say there. Jackson filed a dissent in which Gorsuch joined. That's exciting. Okay. Let's see if there's anything here I want to discuss. It's pretty simple. It's just a preemption case. It's nothing really like exciting to really discuss. It's just kind of a banal. But Gorsuch actually dissents, which, I like Gorsuch. So let's see what he has to say, or Jackson has to say, and Gorsuch signed on to. Okay, my computer has frozen. At least my browser's frozen. Okay. Just that one page froze for some reason. Interesting. Okay. All right, see what Justice Jackson had to say about this Monsanto preemption case. Okay. So it's just an issue about whether or not they did preempt or not. Fair enough. Whether it's expressly preemptive. Hmm. Blah, 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 blah. Hmm. Okay, so the idea is that this is not actually in conflict with federal law, and it might not require the federal government to, it might not require a labeling change, but if the federal government would require it, the failure to put it on there can be sued for under state law. Okay. Mm, okay. Okay, so the idea here is actually a little bit more interesting and a little bit more nuanced. The idea here is that just because the label was approved by the EPA does not mean that the EPA was God. Okay. So if the statute requires you to warn, so here's what the minority is saying in this decision, and it's an interesting point. They're saying if the relevant law requires you to warn, the relevant federal law requires you to warn. Okay. Even though you went through the process of having your specific label approved by the EPA, it doesn't necessarily guarantee that you are in compliance with the law with respect to what the labeling requires. So, what they're trying to say is, what the minority is trying to say is, I think what they're trying to say is, the federal law requires you to warn about various things, including, for example, cancer risks. Okay. That is an obligation you have. You also, separate and apart from that, have an obligation to get your label for your product approved by the EPA. So you submit your label for approval by the EPA. The EPA approves the label. That, however, that regulatory obligation does not preempt your obligation to warn about the things that you need to warn about. So if the EPA approves a label that does not adequately warn about the dangers of your product, you can't use the fact that EPA approved your label as a shield. Okay, that's what I'm getting. And a state can therefore sue. You can therefore have a cause of action under state law for the failure to label because the state cause of action is based on a federal obligation. So there's no conflict. So I think that's what they're trying to say. Yeah. So this is where it's sort of, this is where this sort of is boiling down in this decision here. This is dissent between Jackson and Gorsuch. And what they write in dissent on this issue is, this in turn must mean the EPA's not infallible approval of the pesticide label does not establish a rule of law that must be obeyed when it comes to the pesticide label. Because the EPA registration decision is not conclusive of the label's compliance with the statute, that registration decision itself cannot carry the force of law, must let capture the universal requirements with which a manufacturer must comply to prevent its product from being misbranded in violation of federal law. To conclude otherwise would turn the registration decision from prima facie evidence of compliance into conclusive proof. So it defies logic to treat the EPA's approval of a pesticide label as creating a legal requirement when the approved label may not itself comply with the law. That's a fairly cohesive argument to me. I'm pretty sure Gorsuch wrote that part and not Jackson. Yeah, this is a joint opinion from Jackson and Gorsuch. Who do you think wrote that? Do you think Jackson wrote that, or do you think Gorsuch wrote that? I think Gorsuch probably wrote that. Just getting some subtle clues here. The EPA approval of the label cannot set a requirement for the purposes of compliance. Instead, the requirements, misbranding prohibition, and implementing regulations dictate the contents of the label. This is so because it makes clear the misbranding prohibition continues to apply to pesticides even after they've been registered. The upshot here is that even though the EPA approved of the Royal Shouts label, that label could still lack the necessary warning. Yep, I buy that. That makes sense. I'm not sure whether or not I agree with it, but it makes sense. Okay. All right. Well, I think that will conclude us for today. I think that will conclude Supreme Court time. So, when is the next Supreme Court decision announcement? Do we know yet? Monday? The porch is not inside your home regarding the Fourth Amendment. You're wrong on that one. Okay. Sure. Let's go with that. All right. Monday is Supreme Court announcement day. Excellent. Then Monday it is. We're going to have more exciting decisions on Monday. So how many do we have left? That was 5 decisions today out of 12, so 7 decisions left. So they could hypothetically dump all those decisions on Monday. That would be a long day, but it's possible. Are they going to dump everything on Monday at the start of the week? I don't know, man. feels like odd. Do they have any other announcements, decisions announced beyond Monday? Could do more today? Nope. No more today. That's the end of the day. Was it only 4? Yeah, but one was consolidated, so that's 5. It's 4 documents, but 5, yeah, it's 5. Because one was joined. I think. So I'm counting it anyway. I'm trying to see if there's a calendar. Okay, let's see. Today's the 25th. Well, the 29th is a non-argument day, but it's not listed as. And it's the 29th. It's the end of the month. Are they really going to dump 7 cases on the 29th? They might. I mean, it's certainly unusual for them to go into July. It's been done like once, like in 20 years. Are they going to dump 7 cases on the 29th? I think they are. I think they're going to try to dump 7 cases on the 29th. The calendar changes every day? Yeah, I know. Are they going to try to squeeze in another day on the 30th? Yeah, may announce opinions. They always say that. They never say they will. They always. I don't know the Supreme Court has ever said that they will announce opinions. I think they always say may, because it's the Supreme Court. They're not going to say will. What do you think? What do you think they do? What do you think? Like, what do you think we do here? Right? So like, we're not going to say will. So, yeah, yeah, yeah. What do you think we do here? Do I know why Supreme Court ends in June? Not off the top of my head. I'm pretty sure the first Monday in October is statutory, but why the end of June? I don't know. I don't know off the top of my head. I mean, they deserve a summer recess as much as anybody. They work hard. I'm going to Disneyland Tokyo. I'll tell you what, man. We're Disneyland Paris. Do I ever review bills to make them make sense? I've done it before. Usually, if they're a little bit more in a final stage, because, bills go through changes. So, yeah, Monday's going to be the big decision. I think 7 decisions. Yeah, that could definitely be. They're going to dump 7 decisions on Monday. That sounds like a bad decision. If you're going to announce it on Friday. Like, do a Friday dump day. Doesn't the Supreme Court know that Friday is trash day? You take out the trash on Friday. You don't announce on Monday. You announce on Friday. You announce it so it doesn't make the newspapers. Stupid Supreme Court. And hey, this July 4th is 250th anniversary of America. So it's a special one. That'd be good. The release opinions on July 4th. That'd be good. Federal holiday, 250th, just to make a point. We're going to release a decision on July 4th. Go! That'd be good. That'd be good. We're going to meet on a federal holiday. Wait, what? It's 10 in the morning. We have plenty of time for the barbecue and everything. We can have our Supreme Court session on July 4th at 10 a.m. We'll be done by noon. Plenty of time to get to the lake and cook up some hot dogs. No problem, man. It'd be great. The 4th is a Saturday, is it? It is Saturday. That'd be good. Does the Supreme Court work that hard? Yeah. Yeah, they work pretty hard. It's a tough job, man. It's definitely a tough job. Well, my friends, I think that's going to sign us off for today. I've enjoyed this today. I hope you have too. This has been a lot of fun. We haven't done as many lives. Tomorrow, I'm planning on doing a reaction to a video from another channel that had on a left-leaning law professor to say mean things about the Constitution. And so I'm going to do a edited video reacting to this stupid, and it'll be a little bit longer than my normal edited videos because there's so much stupid. And then on Monday, we will do Supreme Court Reaction Day because Monday is going to be the big day. It sounds like we're going to get our birthright citizenship case, which I hate to disappoint you, but will go against the administration. I'm almost certain of it. They are going to rule that the children of illegal immigrants are natural born citizens. So that's going to happen. They'll, of course, rule that the trans athletes can't be forced to compete. That sex-based discrimination, sex-based sports is still okay. So they'll say that. The mail-in ballots thing, I don't know which way they're going to go on that. If I had to bet, they're going to say that ballots must be received by election day. So that's probably the safe money. What else is still pending? You don't think they're going to rule in the merit of birthright, only that Trump can't do what he did with executive order? You think they're going to kick it? Yeah, that makes sense. Yeah, they don't really decide the question. They just somehow decide that the executive order itself was invalid for some reason. I could definitely see that. They try to avoid the merits question. Punting is a bad idea. It's the Supreme Court, man. They don't. Yeah, the Supreme Court loves to punt, and that's a great case to punt on. Like if they can avoid the question, I'd look to punt. If I were on the Supreme Court, I'd be looking for a punt right about now. I'll tell you what. I'd be looking for an escape hatch real hard. Yeah. I don't want a piece of that bullshit. Griswold, Colorado AG. I don't know anything about the gentleman. I don't follow Colorado politics. So I can't really speak to that. If they punt, Trump's going to make a corrected order, assuming he can. But they'll look for a way to beat the clock. Hope the next president rescinds it or something. The Supreme Court can slow down if it really wants to. I mean, the Supreme Court can find ways to buy time. So if they want to punt this thing and try to wait for the next administration, they can pull it off. They just let the stay in place and they just slow walk it for whatever reason. They can figure it out, I'm sure. All right, guys, I'm going to sign off for now. This has been fun. I'm going to take a break, chill out a little bit, eat some brisket that I cooked, go to the gym, and generally have a good life. I love you all, but we'll sign off for now. Till later, my friends, I hope all is well. Cheers for now, my friends, and goodbye.